Have you been laid off or let go recently? And now there's this severance agreement in your inbox, pages of legal language to review, maybe a deadline to sign it by, maybe some pressure from human resources saying something like, this is just standard. Well, hold off. Before rushing to sign that, you should watch this video because it's important to understand your rights before you sign this thing. This is a contract that could affect your future. Some severance agreements contain language that could affect your ability to work in your industry. It can affect the kinds of things you can say about your employer, and it can also affect your pocketbook. I'm gonna go through the 5 most important parts of a severance agreement in this video to help you understand whether or not you should sign this thing or not. Number 1, the most important part of a severance agreement for some people is the release of claims. And it's the most important part for the company. This is why companies offer severance packages to people, because they want their departing employees to sign the release so they can never get sued. It's as simple as that. If you sign your severance agreement, you can never sue your employer for anything that happened to you while you work there. Even if you work there for 20 years and all kinds of terrible things happen to you, if you sign that thing, it will stop you from suing them, even if you have a claim. So take it seriously. You look at this part of your severance agreement, they're usually long paragraphs that say things like you waive your rights under, and they list the laws, like all kinds of laws, like literally like 10, 20, 30, 40 laws will be listed. It can go on for 2 pages. And that's the release of liability. And that's really part of the bargain of the severance agreement. If you sign this thing, you are giving up your right to ever sue them for anything that ever happened while you work there. So take it seriously. And importantly, if you believe your rights were violated at the company, especially in connection with your termination, such as a wrongful termination, whistleblowing, sexual harassment, maybe they owe you wages or unpaid commissions. If you sign that thing, you're giving it up, so be careful. If you believe your rights were violated, don't sign that severance agreement until you get personal legal advice from an employment lawyer. This video is just a YouTube video and it's not legal advice. Next is a confidentiality clause. Every severance agreement I've seen has one, but they're usually not that important because most people have already signed a confidentiality clause. For some people, you need to take the confidentiality provision pretty seriously if you work closely with extremely high-level confidential information and that you may want to be using similar information at your next job. It doesn't affect too many people, but there are a few people out there it may be important to. For most of you though, the confidentiality provision is mostly going to just mirror what you've already signed. And all it says is that if there's confidential information that you've obtained while working there, you can't take it with you. Non-disparagement clauses. These are important for some people. A non-disparagement clause will prohibit you from saying negative or bad things about your company, even if they're true. For example, if your company did bad things to you, for example, you were sexually harassed or wrongfully terminated, you can't talk about that and say bad things about the company if you sign this thing. In many states. Take it seriously. Some people also want to have what's called a mutual non-disparagement clause where the company is also prevented from saying bad things about you. Most of them don't come this way. Every once in a while you see them mutual, but that's rare. Sometimes you can negotiate back to the company and make it mutual to a limited degree. For example, if you're concerned that your boss or former colleagues are going to say bad things about you, you could ask the company to put a provision in there that says that those people are constrained from disparaging you. Next, let's talk about non-compete and non-solicitation clauses. Now, if you work or live in a state like California, they shouldn't be there because California prohibits them. That doesn't mean they won't be there. I've seen companies in California put them there anyway. So there's 2 things, non-compete and non-solicitation. They're different. A non-compete clause says, essentially, that if you work in a certain industry and you leave, you can't go work for a competitor in that industry. For example, if you're a baker and you signed a non-compete clause and you want to get a job with another baker, you might not be able to go do that because it'll probably say you can't work for a competitor doing what you do, baking bread for another company that bakes bread. That's a very simple example. In many states, these things are enforceable. You should take that seriously. If one of those are in your severance agreement, know it's there. And if you don't like it, and if you're a baker and you have a job, or you want to go work for another baking company near you, if you sign that thing, you might not be able to do that. So in some cases, those things are so bad, it makes sense just to not sign it at all unless they're paying you a lot of money. The other thing I mentioned is called a non-solicitation clause. This can also be important. It prevents you potentially from taking former clients or customers of yours with you when you go to your new job. For example, a lot of people in sales have developed contacts with their former clients or customers. And maybe they're going to leave and say they get laid off and you're given a severance agreement. So what do you want to do? You want to go to another similar company and maybe bring your old clients with you. If there's a non-solicitation clause in there, it could prevent you from doing that. It can also possibly prevent you from bringing former employees with you. Say you join another company and you know you have some friends back at your old company that could really help your new company out. But if you have a non-solicitation clause in there, it might prevent you from bringing them over. If you're dealing with any of these issues, they can be delicate and there's lots of ways to actually get around them. We do it all the time time for people, but you should probably talk to a good lawyer in your state that understands the law of your state. The law in these areas is very different in different states. Law in New York, where I practice, and California, where I also practice, the laws are very different. I know other states like Illinois and Massachusetts also have very different laws. Important to talk to someone in your state that knows these laws to help you out with those issues. Now let's talk about the money. This is the most important part for most people. Now, a lot of people want to know, is my severance offer fair? Well, there's really no answer to that because companies aren't required to pay any severance at all. So if they're giving you any money at all, in a way, that's a bonus because we talk to lots of people who don't get any severance. Severance is really a custom. Companies do it because they want to pay departing people some money so they go away quietly and agree not to sue them and cooperate. Now, there's sort of a crude tool that we look at to judge roughly whether or not severance agreements are kind of fair or not. It's based upon years of service. For example, most severance agreements explain the amount of money paid, not in terms of just dollars and cents. They don't just say you're going to get $25,000. They usually say something like you're going to get 3 months of severance or 3 months of pay. That's what it'll say. So at our firm and many other firms, a crude judge is to say if you're getting 1 week of severance for every year of service, that's kind of on the low end. But if you're getting up to a month for every year of service, that's kind of on the higher end. And anything in between, like if you're getting 2 weeks for every year of severance, that's kind of a middling okay severance. But we found that people who are higher up in a company tend to get more. For example, a high-level executive might get 1 month severance for every year they work there. Or a low-level worker might get only 1 week for every year they work there. It's not fair, but that's how it goes. We see it happen all the time. But we've also seen people get a lot more severance than that. It really depends on who you are and how important you are to the company, and does the company really want to keep you happy when you're leaving. Like I said, severance isn't governed by any laws at all. Companies are free to give you as much money as they want in a severance package. There's no laws covering this. There's just a custom, and there's that one sort of crude tool that we look at to get a general sense of whether or not a severance is fair or not. Here's the thing. Say a company offers you 3 months severance. It doesn't matter what it is. You can go back and ask for more. A lot of our clients, we advise them to go back and just make a polite request for more money. And sometimes people get substantially more. Just make a request for a modest increase. For example, if you were offered 3 months of severance, you could go to your human resources or your old boss and say, hey, is there any chance you can make a modest increase in the severance offer? Maybe they'll say no. It's okay. You miss every shot you don't take. And I've never seen anyone have any adverse consequences from making a polite request for more money other than getting a no. Finally, beware of time pressures. Sometimes companies will call you into an office and put a piece of paper or the severance agreement in front of you and say, sign. Don't do that. Just resist that. If a company's doing that, that really raises red flags. It means you probably did something wrong and they're trying to pressure you into doing it. Most good companies don't do that to people. They'll give it to you and say, hey, they'll give you plenty of time to review it and think it over. So if a company puts you under that kind of pressure, try to resist doing that. Now, if you're over age 40 and your severance agreement has a waiver under the ADA, they have to give you 21 days. That's a federal law. It applies in all states. And in most situations, we're able to go to companies and ask for more, and companies are usually more than happy to give you another week or even more to review it. If you're reviewing a severance agreement and you need help from a law firm and you live in New York or California, our firm has a review and consultation service specifically designed for severance agreements. It's explained in the video right up here. Take a look and we're happy to help you. For everyone else, I hope this video is helpful and helps you understand your severance agreement. I'm Robert. Thanks for watching.